Good evening. Good evening and welcome to the August 2015 Oakland County Campaign for Liberty meeting and Liberty Action Briefing. What a tremendous audience tonight. Please give yourselves all a big round of applause. This is just a fantastic group. As always, we have wonderful speakers, but tonight is super special, of course. And yes, a big round of applause for our super special guest, the great KrisAnne Hall. Okay, ladies and gentlemen, with no further ado, the outstanding, the incomparable, the great leader, KrisAnne Hall.
All right, so, we're in a very serious situation, and I'm afraid we're looking in the wrong places for the answers. Do you realize that we have 15 months before the presidential election? And all we can talk about is two people. You see, changing out the occupant of the White House is not going to change anything about how Washington, D.C. works. This presidential election, I fear, is nothing but a distraction from the real issues that Americans should be really concerned with. Because I want to impress upon you that I strongly believe that this presidential election is completely and totally irrelevant to the fate of America. Because you see, the president doesn't have the power that he pretends he uses. The control of the president is Congress. Do you know that the President of the United States is not the only person up for election on November 8, 2016? I want you to know there are 469 seats in Congress that are up for election on November 8, 2016. Can you imagine? Besides those 469 seats in Congress, there are over 20,000 seats open across America in local and state governments that will be up for election on November 8, 2016. So why is it that we are so obsessed to blindness over a presidential election that is really, really inconsequential? Because if we got behind 469 seats in Congress, we would have a Congress that knew that the president does not have the power to make deals outside treaties in the Constitution. We would have a Congress that realized the president doesn't have the right to write law and overturn law and set aside law. We would have a Congress that would realize it has no business funding the EPA, the FDA, the Department of Justice, the ATF, or any of these ABC agencies run by the executive branch.
Hell yeah, that's right.
You see, if we could get really behind 469 seats in Congress, we could change the world. But instead, we'd rather be distracted by one person or two people for the next 15 months. Over 20,000 seats available in our state and local governments. Somebody told me somewhere around 38,000 seats available in our state and local governments up for election on November 8, 2016. Do you know what we could do in America if we had constitutionally minded school boards? Constitutionally minded city council, county commissions. Constitutionally minded sheriffs. Yeah. If you had a constitutionally minded sheriff, the federal government would have absolutely no jurisdiction in your county, and there would be nothing that they could do about it. And oh my goodness, what if Michigan would become a constitutionally minded state? Yes. You see, the solutions to our problem are not changing out the occupants of the White House. That is a siren song, that is a Pied Piper call, and the sheep are falling in line. We've got to turn off the news and start looking local and getting involved. And that's what we're going to be talking about tonight. These are the solutions. Because guess what? The federal government's not going to fix itself. The president is not going to limit himself. And everything that we have seen in the last 40 years with Congress, we know the Congress is not going to limit the president or do anything about a Supreme Court out of control. Do you know the president is not the leader of America? He was never supposed to be. The president is only the leader of the Army and the Navy when there's a formal declaration of war. When there is not a formal declaration of war, Congress is in charge of the military. So isn't it about time we start correcting our perspective and start focusing on things that are really, really important and really, really will result in change? It's my personal opinion that you could ignore federal elections for the next 6 years and nothing would change in Washington, D.C. But you know what would change? If you ignored federal elections for 6 years and focused every dime and every minute on your local elections, you wouldn't care what the federal government's doing. And then we might actually raise up a population who realizes that the federal government is stealing money from us under false pretenses and then extorting power from the states with our own money, and we'll stop funding them to do that. But that's only going to happen when we really, really turn off the music. Now, what we're going to talk about today is not really Article 5 versus nullification. It is not which one, either or. This is a discussion on both of these principles. They are both constitutional remedies to federal government out of control. And the beautiful thing about this, you don't have to choose. They are not mutually exclusive. And as a matter of fact, if you don't employ one, you will never get to the other. But I will get ahead of myself and let the cat out of the bag, so let's just keep moving. In order to understand the real solutions to federal government out of control, the story always begins with sovereignty. You see, you can't do anything to fix a federal government until you understand the principles of sovereignty. And in order to understand the principles of sovereignty, we're going to have to get back to some real basics. And I mean ABCs, 1, 2, 3s. I'm going to be asking you questions. You're going to roll your eyes at me and go, come on, KrisAnne, come on, make them harder. This is ridiculous. But I have found that sometimes when we take the beginning steps for granted for so long, we fail to connect important dots and see the real big picture. So here's your first question. Which came first? The states or the federal government? States. Obviously, right? That's a no-brainer. But you know what? That one simple thought, if we realized that, we wouldn't even be in this meeting today because we wouldn't have a federal government out of control. The very nature of natural law comes into play when you realize that the states came first. Because then you see who created the federal government. The states created the federal government. Natural law says you cannot create something greater than yourself. Which means the states are sovereign over the federal government. Because if we knew that they came first, that would just be a no-brainer, right? So let's look at the chronology of this, right? The states came first. We love to teach our children. We love to celebrate our independence on July 4th. We talk about the fact that we became independent from Great Britain on July 4th. We did not become independent from Great Britain on July 4th. We became independent from Great Britain on July 2nd, 1776. A simple fact that being neglected as it is, allows our progressive education system to teach our children that because we became independent on July 4th with the signing of the Declaration of Independence, what really happened was a bunch of rich guys who wanted to oppress everybody met in a pub one day and decided they didn't want to be under this king anymore, and it would be better to create their own government so they wouldn't have to pay taxes and they could take rights and liberties from everybody else. And then in turn, they accidentally created America. Now we giggle, but I have actually read a rendition of history like that in our current Common Core school books. If they go back that far, that's what they're teaching. That it was an accident. But you see, they have to ignore the fact that we actually became independent from Great Britain on July 2nd because that fact doesn't support their lie. On July 2nd, 1776, the Continental Congress met. Richard Henry Lee had presented the Lee Resolution the month prior. The Lee Resolution was a 3-step process to declaring independence from Great Britain. Step number 1, we're independent from Great Britain. Because we say so. Because we hold these truths to be self-evident, that all men are created equal and endowed by their Creator with certain inalienable rights. And since God gives us rights, we don't have to ask permission from the king anymore. So we're independent. Step number 2, we must get foreign help because we don't have the manpower or the resources to overthrow the most powerful government in the world. And step number 3, we must immediately form a confederation because the only way we're going to maintain liberty if we actually win it from Great Britain is to come together. Thomas Paine said it is not in numbers that we gather our strength, but in unity. And on July 2nd, 1776, the Continental Congress met. They brought the Lee Resolution to the floor. They debated, they voted, and they ratified the Lee Resolution into law. Our independence was created by a law, just as legally binding as anything that our Congress does today. That's constitutional. John Adams would be so excited about what they did on July 2nd that on July 3rd he wrote home to Abigail and said, July 2nd will be an epic day where Americans will celebrate their independence forever. Which means we became states 2 days before the Declaration of Independence. And then on July 4th, we published what we did on July 2nd. And don't you know, human nature, we always like to believe what we read in the newspapers rather than what Congress really did. Right?
Thank you. Thank you.
Now, that means we not only existed prior to the Declaration of Independence, but we also, the states existed prior to the Articles of Confederation. Now, the Articles of Confederation are the first place you see a legislative, an executive, and a judicial branch. But the interesting thing is, they made the Articles of Confederation. When they made the Articles of Confederation, they created a federal government so small it could not function the way it was supposed to. It did not function properly. We were on the verge of foreign war. We were on the verge between a war between the states because the federal government was not operating properly. So in response to that, the Congress got back in session and said, you know what, this isn't working out. We are going to dissolve the Articles of Confederation. At the point we dissolve the Articles of Confederation, there is no more legal standing, legislative, executive, or judicial branches. The only sovereign government that exists are the states. Which means the states are the only governments that existed when the Constitution, the more perfect union, was ratified. So now we understand the real chronology behind when did these states come about. Now we need to know what is a state, because we've forgotten what that means too. This is the last paragraph to the Declaration of Independence. Interestingly enough, it's also nearly verbatim to the first clause of the Lee Resolution. We, therefore, the representatives of the United States of America in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do in the name and by the authority of the good people of these colonies, Don't you know that phrase was a real poke in the eye to the king? Just publishing and declaring, we don't need your permission anymore. And look where the power comes from. Where does the power come from? The people. Governments to secure these rights. Governments are instituted among men, deriving their just power from the consent of the governed. And by the authority of these good people of these colonies, solemnly publish and declare, see, we didn't become, we are simply publishing and declaring, that these united colonies are, and of right, ought to be free and independent states. Now that statement tells us what a state is not, right? Because we were colonies, and now we're states. Which means states are not colonies. So what's the difference between a colony and a state? A colony is not independent. A colony is not free. A colony has no autonomy. It is not sovereign. A colony can do nothing without permission from the king. And if we're going to understand what we need to know about nullification and about Article 5, we've got to get these basics about sovereignty down. And we know that states are not colonies, so what are states? Continuing with the Declaration of Independence, in our last paragraph, we left off with the phrase, free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and what? Of?
Great Britain.
The state of what?
Great Britain.
That word state is not simply synonymous with Rhode Island, New York, and Virginia. That word state is synonymous with Great Britain, France, and Spain. When we created 13 free and independent states, we created 13 free and independent sovereign countries. That's what that word state means. Sovereign country. But what kind of power did the people delegate to the states when they created them through the Lee Resolution? Well, this is going to tell us. So all political connection between the states and the state of Great Britain is and ought to be totally dissolved, and that as free and independent states, just like Great Britain, France, and Spain, they have, our states have. Look at the power our states have. Full power to levy war, conclude peace, contract alliances, establish commerce, and do all other acts and things which independent states may have right to. That is the power of Michigan. Every state was created with that power, and every state that joined the Union with that power. And nothing has changed. Somebody, I like to call them federal supremacists. You know, those people that tell you that the supremacy clause means that the states have to submit to whatever the federal government says, you know, or that the Supreme Court issues rulings, right? How many of you know Supreme Courts don't issue rulings? Kings issue rulings. Courts issue opinions. And when their opinions are outside law, you are no more bound by their opinions than you are the opinions of your next door neighbor. So, they're going to tell you that changed when we joined the Union. That when we joined the Union, we surrendered our sovereignty and we surrendered power to the federal government. You realize that is so wrong. Let me ask you a question. How many of you heard of a sovereign country by the name of Germany? Everybody heard of that? Okay. Didn't Germany join the European Union? Okay. So buy a plane ticket, fly over to Germany, and tell the German people and their chancellor in a big public forum that they are no longer a sovereign country because they joined the European Union. How do you think that's going to go over? So why do we accept that here? We sort of laughed at the supposition that Germany would accept the fact that they're not sovereign. So why do we allow Michigan or New York or Florida to believe that? Because we've been taught the wrong things for a very long time. Now, We know the states came first. We know the states means that they are independent sovereign countries with all that power that we delegated to them through the Lee Resolution on July 2nd. Now we need to understand the nature of the Constitution. What is the Constitution? The Constitution is a contract. A legally binding contract. It is written like a contract. Its sections are laid out like a contract. It even has clauses that mirror contracts. But the interesting thing is, our framers don't call it a contract. They call it a compact, which is even better for understanding sovereignty. Because a contract is an agreement between people. A compact is an agreement between sovereign governments. So that means the Constitution has to be an agreement between the only sovereign governments that existed when we ratified the Constitution. Who were the only sovereign governments in existence when we ratified the Constitution? States. The states are the only sovereign governments that could have created the constitutional compact. What is the product of our Constitution? What did we create when we created the Constitution? The federal government, right. We created the federal government with the purpose, as the preamble says, to preserve the blessings of liberty to ourselves and our posterity. Prior to the ratification of the Constitution, there was no legislative branch, executive branch, or judicial branch as a central government. They were the product of the contract. When you have a contract, you have parties to a contract, and you have a product of a contract. The only sovereign governments that existed who could be the parties to the contract are the states. And the product of the contract is the federal government. Somebody, this is important, these little steps, because somebody's going to try to tell you that I'm lying to you, that the states are not the parties to the Constitution, the agreement, those who make the agreement in the Constitution. They will tell you that the Constitution is an agreement between the people and the federal government. Not true. Do you know how the Constitution was ratified? By 3/4 of the states. We did not hold a popular vote to ratify the Constitution. The people did not vote on this. The Constitution became the supreme law of the land because the people's representatives that we called the states made the agreement. Somebody might try to tell you that the Constitution is an agreement between the states and the federal government. Also not true, a temporal impossibility. Why? Because the central government is what? The product of the contract. You cannot be the creator of the contract if you are the product of the contract, because you don't exist until the contract is created. So the only sovereign governments that could create this compact were the states. The states are the creators of the contract, which means the states are the creators of the central government. They enumerated its specific powers. They created a limited central government, and then they did the most important thing they could ever do. They reserved all other powers to themselves. That word reserved is very, very important. It has a really big meaning. Now, we know that the states are the creators of the contract, that they created the central government. We also remember from natural law that you can't create something greater than yourself. And we know that the states are sovereign and independent. They can't have created an entity bigger than themselves, so the federal government must be inferior to the sovereign states. So now we need to keep the proper perspective on power. We talked about the fact that we have created the central government. We have reserved all other powers to the states. What is that power perspective? This is from Federalist Papers 45. James Madison says, the powers delegated by the proposed Constitution to the federal government are few and defined. We put them in a box. He says the powers which are to remain in the states are numerous and indefinite. look at this. The powers delegated by the proposed Constitution to the federal government will be exercised principally on external objects. That's founder speak for foreign affairs. Now, Madison doesn't wait around for the Supreme Court to identify what external objects are. He tells us war, peace, negotiation, and foreign commerce. That's all the power we ever delegated to the federal government. Powers concerning foreign affairs. Because look at this. Madison tells us the powers reserved to the several states will extend to all the objects which in the ordinary course of affairs concern the lives, liberties, properties of the people, internal order, improvement, and prosperity of the state. Where is the power of environment? In the states, right? Where is the power of land management? In the states. All of this power is reserved to the states. The only thing that was ever delegated to the federal government was foreign affairs. We basically made this federal government to be an agent, an ambassador on behalf of the states in foreign affairs. And so when you interpret the General Welfare Clause and the Tax and Spending Clause and the Commerce Clause and all these clauses that they like to expand to mean something they don't, the contract says you first must remember these are the only powers that were delegated, so those clauses can only reflect this power. Now, Jefferson says, whenever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. Do you know what that means? That means when the federal government exercises a power that's supposed to be reserved to the states, the exercise of that power has no force. Let's look at that from with this analogy. If I steal your car, do I have the authority to use it?
No.
Do I have the authority to sell it?
No.
If I sell your car, is that sale legally binding? No, because I have exercised a power that does not belong to me. So any exercise of that power has no legal force. Jefferson's saying we didn't delegate environment to the federal government. We didn't delegate ATF and gun management and ammunition to the federal government. And any exercise of those powers that were not delegated or simply have no force. Madison, John Calhoun talks about this. You realize this is not our first rodeo with the federal government out of control, right? They started getting out of control in 1792. James Madison has to teach them about why the federal government can't subsidize industries all the way in 1792. Then they're leaping out of their box again in between 1798 and 1800. And then they're leaping out of their box again in 1830. It's called the Great Debate of 1830. And Calhoun tries to really help us understand the importance of this word, reserved. The doctrine which denies the states the right of protecting their reserved powers. This is so important. You realize the 10th Amendment says the powers not delegated to the federal government are what? Reserved to the states or to the people. To the people, because we're the origin of all power. And even if the states go crazy, we can take that back from them too. Remember, the Declaration says when any form of government operates contrary to those means, it's the right and the duty of the people to alter or abolish it. Any form. And so what Calhoun is trying to explain, have us understand, is this reserved. So let's take this as another example. Let's pretend this chair up here has a sign on it that says, reserved to KrisAnne Hall. If someone else sits in that chair, what do I have the authority to do?
Kick them out.
Kick them out. Why? Because it's reserved. It's reserved to me. I have the authority to secure to me what is reserved to me. If it says reserved and somebody sits in it and I don't have the authority to kick them out, is the chair really reserved? No. Calhoun says, because the powers are reserved, the states have an inherent right to protect unto them what is reserved to them. And if you take that right away from them, you know what you're doing? You're leaving the extent of the federal government's power in their own hands. they will decide what their power is. And he says, if you let the federal government decide whatever power they want to have, then guess what? The Constitution is no longer in effect. And if the states must just go along with whatever the federal government says, are they sovereign? They're colonies. Now look, sovereignty is the key to liberty. The design solution, Madison says, within our constitutional republic is, in the case of deliberate, palpable, and dangerous exercise of other powers not granted, the states have the right and are in duty bound to interpose. Why? Because we created them first. And we created them with the purpose of securing our liberty. Then they created the central government in a limited and defined way with the purpose of preserving liberty to ourselves and our posterity. And because the federal government is the creation of the states, it is the duty of the states to keep their creation under control so they don't run wild and steal all our stuff.
Amen.
Jefferson says this in 1798 as well. The several states who formed the Constitution. See, you guys thought I made that up, right? Being what?
Sovereign.
And? Have the unquestionable right to judge of its infractions. Why? Because they are the creators of it. And that a nullification by those sovereignties. Who are the sovereignties? States. Of all unauthorized acts done under the color of that instrument is the rightful remedy. Do you know that nullification really isn't an act? It's an assertion. It's simply stepping up and saying, you can't drive around in my stolen car anymore. I'm taking it back. It's not an extra power. It's inherent in their right to secure what is reserved to them. And Jefferson calls it nullification. Madison calls it interposition, but they're all the same thing. You control your creation. Now, this is where understanding nullification works, because you see, you can't understand nullification until you understand sovereignty. And now we understand that the states are sovereign, independent countries that created the central government. And your federal supremacists are now going to attack you with these. These are the most popular attacks on nullification. That the Supreme Court said no, that it's not in the Constitution, the Supremacy Clause prohibits it, which, by the way, is my favorite one, because it's the easiest one to overturn. And it proves that anybody who says the Supremacy Clause nullifies nullification, it proves they never actually read the Supremacy Clause. Or they're admitting they're illiterate. Either way, it works out the same. So let's look at this. Is the Supreme Court supreme over the states? Of course not. And Madison tells us as clear as anybody could. If the decisions of the judiciary be raised above the authority of the sovereign parties to the Constitution. Who are the sovereign parties to the Constitution? So you could read that by simply saying, if the decisions of the judiciary be raised above the authority of the states, dangerous powers not delegated may not only be usurped and executed by other departments, but that the judicial department also may exercise or sanction dangerous powers beyond the grant of the Constitution. Consequently, the ultimate right of the parties to the Constitution. Who are the parties to the Constitution?
States.
The ultimate right of the states to judge whether that, what's that word there? Compact has been dangerously violated must extend to violations by one delegated authority as well as by another, by the judiciary as well as by the executive or legislative. You know what Madison is just simply reminding us? Number one, the states are sovereign. They are sovereign over their creation. And we have three branches of government: legislative, executive, and judicial. The judicial branch is part of the federal government. And Madison's just simply saying it makes absolutely no sense if you're going to allow the part of the whole to define the power of the whole. Because if the part of the whole can define the power of the whole, then what is the limit of the whole? Just its own will. Now, Madison engages in a debate with the House of Representatives over the incorporation of the Bill of Rights into the Constitution. There is a debate over this, by the way. There are some people who think that incorporating the Bill of Rights into the Constitution will be dangerous. We don't need to write down our rights because we have already limited government in the original document. Hamilton says, why do we have to tell the government not to do something when we've never delegated a power for them to do it? And he says, if you write down the rights, you're going to make a problem because those who want to be dishonest and take your rights will use that as a tool to do so. So somebody in federal government will say, that's a really great list you've got there, and we certainly don't want to infringe upon anything in that list. But oh, wait, oops, that one's not on the list. And since it's not on the list, it must be okay for us to regulate it because you didn't put it on the list. Or they'll say, look at that liberty of press thing. We certainly wouldn't want to abridge your liberty of press because you put it on the list. But you see, in order to not abridge it, we don't want to accidentally do that. We don't know what press is. So what we're going to have to do is define press so that we don't accidentally infringe upon it. And then, oops, wait, that's obviously press, isn't it? I mean, press as it was written 200 years ago. They had paper and journalists and media and that sort of things, so that's definitely press. But you know what? 200 years ago, they didn't have that internet thing. So that must not be press. And since it's not press, it's not on the list, so it must mean that it's okay for us to regulate it. Now, Madison had made a very big promise to the people of Virginia that he would make sure that we had this Bill of Rights. And so he has taken it upon himself to make sure that we do. And this is his argument against that idea that they'll simply be able to define our rights away from us. He says if they, the Bill of Rights, are incorporated into the Constitution, independent tribunals of justice will consider themselves in a peculiar manner the guardians of those rights. They will be an impenetrable bulwark against every assumption of power in the legislative or executive. They will be natural. Did you catch that? In the legislative or executive? It doesn't say states, does it? He's not asserting that the courts have an authority over the states. He's asserting that the courts have an authority over the legislative or the executive. He says they will be naturally led to resist every encroachment upon the rights expressly stipulated for in the Constitution by the Bill of Rights. Why would Madison have this kind of confidence in the courts? Because Madison now knows something that you know, that the Supreme Court does not know, or they refuse to acknowledge. The Constitution is a contract. Madison is simply saying, because we know we've created a contract, if there's a question about the clauses or the words, how they apply, what they mean, they're not going to be able to sit around and just make up definitions, because the courts will know that in order to interpret a contract properly, you must follow contract law principles. And contract law principle number one, every law student learns in the first semester of law school, is that in order to properly interpret a constitution, you have to go to the writers of the contract. It's called the meeting of the minds. And Madison's saying, look, we wrote all this stuff down. We have papers and papers and notes and everything. They won't be able to make it up as they go along because the courts will force them to go to our meanings for these words. Do you know what the irony of that is? The Constitution is the only contract in the United States where judges and lawyers refuse to apply contract law. Now, we might be in a fix if this was the last statement Madison said on this, but his very next statement is this. Watch this. Besides this security of the courts following contract law, there is a great probability that such a declaration in the federal system will be enforced because the what? The state legislators will jealously and closely watch the operations of this, the federal government, and be able to resist with more effect every assumption of power than any other power on earth can do. And the greatest opponents to a federal government admit the state legislatures to be the sure guardians of their liberty. Your states are supposed to be the greatest opponents to the federal government, jealously guarding the power that has been reserved to them, not their biggest fans and their best friends. Now, some will like to tell you that nullification only works if you have every single state in the union agreeing to nullify the laws. In each specific law, all 50 have to agree to nullify each specific law. Because if we don't, there'll be anarchy throughout the land. Do you know what's really interesting about that claim that the states nullifying federal law is anarchy? Is it's not true. Why would the states nullify federal law? Because the federal government is acting outside the Constitution. It's really the federal government that's acting in a lawless manner. It's the states holding together the Constitution and enforcing the supreme law of the land. Madison does not tell you that all the states have to be in unison. They'll provide you with a quote taken completely out of context. He says this: but ambitious encroachments of the federal government on the authority of the state governments would not excite the opposition of a single state. He's not saying you have to have all of them. He's saying we don't need to worry about it, because if the federal government attacks one state, all of them will fight back. He says it would not just excite the opposition of a single state or a few states. There will be signals of general alarm. Every government would espouse the common cause. A correspondence would be opened, and plans of a resistance would be concerted. One spirit would animate and conduct the whole. And then he makes the most brilliant statement that describes our government today. He says, but what degree of madness could ever drive the federal government to such an extremity? Well, it's not in the Constitution, they say, which is a really good news. Because we know from the 10th Amendment, the powers not delegated to the federal government are what? Reserved to the states. So if it's not in the Constitution, then we know it's a power what? Reserved to the states. But we also know it is in the Constitution because it's the application of that word reserved. Nullification is not a separate power. It is the expression of reserved. It is protecting what has been reserved to them. And we know it's their power because we have the power here to give it to them. That's what the 9th Amendment says. All the rights of the people belong in the universe. All the rights in the universe belong to the people. So it's there. The Supremacy Clause prohibits it. Hamilton makes it very clear. Now, Hamilton's your biggest government guy. Everybody hates Hamilton, who likes the anti-federalists. But even the big government guy says, no legislative act contrary to the Constitution can be valid. I know the framers are hard to read sometimes, but I don't think it gets any clearer than that. Because that's exactly what the Supremacy Clause says. Look at this. This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. Do you see that? It's very simple. This Constitution shall be the supreme law of the land. It's the Constitution, so it is the supreme law of the land, without any qualification. But the laws of the United States are not the supreme law of the land unless they are made in pursuance to the Constitution. So if federal laws are made outside the context of the Constitution, they are not the supreme law of the land. And after all, that means it's an unlawful exercise of a power that doesn't belong to them, which means it is no law at all. And that's why this is important to understand. Justice Roberts also agrees with nullification. Did you know that, Dennis? This is the first Affordable Care Act opinion written by Justice Roberts. Look what he says. We look to the states to defend their prerogatives by adopting the simple expedient of not yielding to federal blandishments when they do not want to embrace federal policies as their own. The Supreme Court Justice is saying when the states don't want to use the federal, recognize the federal powers, when they're beyond their reach, they don't have to. And then look at this. This is the most brilliant thing. I was trying to figure out how I could blow up that second red clause because it's just beautiful. The states are separate, independent sovereigns. And sometimes they have to act like it. Jefferson gives us our transition here. It is important to strengthen the state governments. And as this cannot be done by any change in the federal constitution, for the preservation of that is all we need contend for. It must be done by the states themselves, erecting such barriers at the constitutional line as cannot be surmounted by either themselves or by the general government. The only barrier in their power is a wise government. A weak one will lose ground in every contest. So now we talk about Article 5. Because Article 5 is in the Constitution. How many of you know Article 5 is in the Constitution? Right? Article 5 is a mechanism that our framers gave us to amend the Constitution when it became necessary. Not for light and transient reasons, but for really, really important principles. Because you see, the Constitution is not a statute book. It doesn't tell you that you can only drive 75 on the interstate. The Constitution is a document of time-tested, blood-bought principles. And that's what the Constitution, even the Bill of Rights, is supposed to be built upon. So they never really intended for us to sort of just get in and play around and make things, convenient. This is Article 5. Now, the important thing about understanding Article 5 is there are two entities involved here. There are the states and Congress. Remember, Congress, on the application of the legislators of 2/3 of the several states, shall call a convention for proposing the amendments. Now, I'm going to tell you a little bit. We're going to talk about what the framers said in this, okay? But you can read lots of stuff about Article 5. I want to do something really different and really important here. I want to show you the concerns and the pitfalls that we might see with a convention so that we can actually have a successful convention and not fall into the trap that we fell into with the 16th and 17th Amendments. Okay? If we're really going to do this, I cannot be against an Article 5 convention because it's there. Our framers gave it to us as a means to amend the Constitution. But we'd better be sure what we're up against and the real purpose for this if we're going to do this. Because Article 5 is open heart surgery on the Constitution. It is not something that we should do simply because we want a balanced budget amendment. Okay? The federal government is already required by law to have a balanced budget. Adding amendment is not going to make them follow it. There's also those who believe that we can have a convention to alter the Constitution and not involve Congress at all. If that's so, then that is a convention that is outside the Constitution, which would be an unconstitutional manipulation of the Constitution because Article 5 gives us those means, and the only other means is that Congress has to be involved. Now remember, nullification is not amending the Constitution. Nullification is enforcing the Constitution. So, why a convention? Why do we have a convention? Remember, it's not for light and transient reasons. Our framers actually believed we would need to amend the Constitution from time to time. And I want to mention to you not to correct the actions of the federal government, but to expand the liberty of the people. I'm certainly not an advocate for frequent and untried changes in laws and constitutions. I think moderate imperfections had better be borne with because when once known, we accommodate ourselves to them and find practical means of correcting their ill effects. But I also know that laws and institutions must go hand in hand with the progress of humankind. As that becomes more developed, more enlightened, as new discoveries are made, new truths disclosed, and manners and opinions change with the change of circumstances, institutions must also advance and keep pace with time. We're not playing catch-up and correction. We're advancing. He says, we might as well require a man to wear still the coat which fitted him when a boy, as a civilized society to remain under the regimen of their barbarous ancestors. Do you know that our framers wanted to end slavery altogether when they formed the Constitution? They offered the amendment process because they realized that we were advancing in the fundamental understandings of liberty as a people. And as liberty grows, liberty inspires more growth. And they hoped that we would be able to amend the Constitution. Why? To limit the government even more and expand the liberty of the people. That's why we needed a convention. George Mason tells us some of the concerns that they had with a convention. He says, amendments therefore will be necessary, and it will be better to provide for them in an easy, regular, and constitutional way than to trust it to chance and violence. He says, look, we have to provide this Article 5 because if you don't set up the standard, then Congress will do it anyway, and who knows what they're going to do. And if we don't set up a way for the people to do that, their only other alternative is bloody revolution. He says it would be improper to require the consent of the national legislature because they may abuse their power and refuse their consent on that very action. That's the intent in Article 5. The limited power of Congress and the power of the sovereignty of the states. But watch what happens as we move forward. Now this is Patrick Henry. Patrick Henry is a wise man and understands human nature. He says it is natural to man to indulge in the illusions of hope. We are apt to shut our eyes against a painful truth and listen to the song of that siren till she transforms us into beast. Is this the part of wise men engaged in a great and arduous struggle for liberty? Are we disposed to be of numbers of those having eyes see not and ears hear not the things which so nearly concern the temporal salvation? For my part, whatever anguish of spirit it may cost, I am willing to know the whole truth, to know the worst, and to provide for it. If we are going to get into an Article 5 convention, we must know the worst possibilities so that we can be prepared to provide for them. And just simply closing our eyes to them and simply saying, no, we need to have a convention, let's just give it a shot and see what happens, is reckless, negligent, and dangerous. So let's look for these pitfalls. These are the questions that must be answered before we can have a successful convention. Who are the delegates? How long will it take? What does Congress think how will Congress think a convention will operate? Because you realize that's very important. Because they're going to seize control of this, and we've got to know what they think about it before we get into this. Is it a limited or unlimited convention? And how will we control that? And this sounds ridiculous, right? Number 6. What is the role of the president in the convention? Well, we know it's 0, but does Congress? The question of who are the delegates is not an invention of my own. It's a concern of James Madison. We are to recollect that all existing constitutions were formed in the midst of a danger which repressed the passions most friendly to order and concord, of an enthusiastic confidence of the people in their patriotic leaders, which stifled the ordinary diversity of opinions on great national questions, of a universal ardor for new and opposite forms, produced by a universal resentment and indignation against the antient government. He's saying, look, the only reason we've been able to have these successful conventions is because we've just come out of bloody wars. And the horrors of what we saw in those wars kept us focused on liberty and not on our own personal gain and our own political advancement and the friends and family members or whatever special interests that might benefit from our decisions. He says the people have to have an enthusiastic confidence in those leaders. Oops. And that we must be confident that they will stick to principles instead of their own gain. Madison's saying, who are the delegates? And then he says, look, I really have concerns about a convention in the future who do not come from these circumstances that drive us to put aside our own greed and avarice. He says, The same influence which had gained them an election into the legislature would gain them a seat in the convention. They would consequently be parties to the very question to be decided by them. Who are the delegates? Do you know the delegates will be chosen by two means? Popular election of the people, or the state legislators will choose who will be the delegates for the states. Who are the state legislators going to choose?
Bad people.
It's gonna, you know what's gonna happen? Because you realize, when you look at a political map, we have red states, we have blue states, we have purple states, right? That means the red states will pick their Republicans, and the blue states will pick their Democrats, which means an Article 5 convention will not be nothing more than a Democrat versus Republican political sport. And that's exactly what Madison is saying. He says, look, you're simply going to choose the same people who created the problem and ask them to fix it. If we do popular vote, who are we going to choose? Let me ask you this question. What's our track record on electing people who are constitutionally proficient and constitutionally minded? He says, I should tremble for the result of a second meeting in the present temper of America and all the disadvantages I have mentioned. How long will it take? Well, these are the steps to an Article 5 convention, to ratification of an amendment. Now, this step must be followed for each and every amendment. I asked Mr. Ferris about this. I said, how long do you think this will take, Mr. Ferris? He said, well, you know, in all honesty, a minimum of 5 years. Okay? I think that's a very generous, a conservative estimate. I'm going to tell you an amendment process will likely take a minimum of 10 years. Right? Because you have to go through all these steps and then you have these. Do you know there are people right now with lawsuits already drafted within their hands to block an amendment process every single step of the way? We will be tied up in litigation for at least 5 years. Do we have 10 years to fix this federal government problem?
No.
No. Over 20 years of real crisis before reaching a boiling point. Do you know how many of you heard of the Silence Do-Good letters? You remember who wrote the Silence Do-Good letters? Benjamin Franklin. Anybody know what year he started writing those letters? 1722. Our independence movement began, by the words of our framers, in February of 1761 with the actions of one man by the name of James Otis Jr. Over 20 years of real crisis before we reached the boiling point. Only 13, and at that time we only had 13 states and only 3 million people in population. It took 14 years to complete and ratify, from the Lee Resolution to Rhode Island ratifying the More Perfect Union in 1790. Not because of primitive communication, but because of debate and amendments. Now we have 50 states with 310 million people. We'll have lawsuits. We'll have Congress to contend with, the Supreme Court to contend with, the executive branch, and political parties. You think we can get this done in 5 years?
No.
I don't think so. What is Congress's role in a convention? It says Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, blah, 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 shall call a convention. And then they will also decide, after the convention meets, as one or the other modes of ratification may be proposed by Congress. So Congress will call the convention, and they will propose the means for ratifying the amendments. Now, that doesn't seem like much, does it? Until you understand how Congress defines the word call. You know government likes to redefining the meaning of words, right? We did a big one with is. Just imagine what call means. This is what call means. Now, Congress must vote to propose an amendment. It must be approved by 2/3 of the members of the present voting, providing a quorum present. Amendments are not incorporated into the existing text of the Constitution. This is what Congress thinks now. According to Thomas Neal, in the Article 5 Convention proposed constitutional amendments, this was actually published in the Congressional Research Service. How many of you realize this is not brand new? Congress has been debating Article 5 conventions since the 50s. They've been having congressional hearings over this and calling in their experts to advise them. The Congressional Research Service has just simply combined all the results of all their experts into one 42-page document. The congressional vote to propose an amendment must be approved by 2/3 vote of members present voting and providing a quorum is present. Amendments are not incorporated into the existing text of the Constitution as declared in 1788, but included as supplementary articles. And beginning in the 20th century, Congress has required that ratifications must be contemporaneous, meaning every amendment must be ratified within a 7-year deadline. This is all wrapped up in this word, call. Okay? These are the things that Congress says. Congress says they have the right to propose amendment directly. They have a responsibility to call the conventions, and they have a responsibility to submit the proposed amendments to the states for ratification. What does that word call mean? According to them, as published in their documents, the requirement of Congress to call a convention means that they will receive, judge, and record all state applications for a convention. That they will establish the procedures to summon a convention. They will set a time allotted for deliberations. They will determine the number and selection of delegates. They will set internal convention procedures and arranging for formal transmission of the proposed amendments to the states. They will become not just simply those who call the amendment convention, but the actual governor and dictator and secretary over the convention. How has Congress really respected the will of the people lately? When was the last time Congress respected the sovereignty of the states? So a convention under the control of Congress, how's that going to work out for us? The question, does Congress even have to call a convention?
Yes.
Obviously they do. Even Hamilton says so. Hamilton says the words of this article are preemptory. The Congress shall call a convention. Nothing in this particular is left to the discretion of that body, and of consequence, all declamation about the disinclination to a change vanishes in the air. Why? Because it says shall. Do you know what? A well-regulated militia, being necessary for the security of the free state, the right of the people to keep and bear arms, shall not be infringed. Ooh, Congress doesn't follow that word shall very well, do they? Look at this. Cyril Brickfield, counsel to the House Judiciary Committee, says, "It is doubtful, however, that there is any process or machinery by which Congress should be compelled to form this duty. There will be no enforceable cause of action." Do you know why? Because in the 1920s, Congress was required to, through the census, to reapportion the House. Congress refused. The states complained, and nothing happened. Cyril says because nothing happened in 1920, it's probably likely that we could refuse to call a convention and nothing would happen again because the states would complain, and then what do we care? Because we're Congress. Congress is the danger. This is what George Mason says. This is from Madison's notes. So he says, Colonel Mason thought the plan of amending the Constitution exceptional and dangerous, as the proposing of amendments is in both the modes to depend, in the first immediately and the second ultimately, on Congress. No amendment of the proper kind would ever be attained by the people if the government should become oppressive, as he verily believed would be the case. Because we put Congress in charge of calling the convention. Mason says, look, I'm trying to warn you, they're going to take control of it. The convention is without authority to propose any amendments of subject matter different than set forth in the current resolution calling for the convention. In other words, the convention, although a sovereign body, is subject to the limitations of the concurrent resolution by Congress. That is a congressional report. Here's the last question. What will be the power of the president in an Article 5 convention? Well, you can read Article 5 all day long and twice on Sunday and never see the president. However, remember, Congress has been debating this since the 50s, and their experts have a different opinion of the matter. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and be therefore and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed by the case of a bill. That's Article 1, Section 7, Clause 3. The experts say, well, an amendment has to go through the House and the Senate. And since Congress is involved in the process, that naturally means under this clause, the president must be involved as well, with a veto power. How's that one going to work out for us? Can I remind you what Madison said? I should tremble for the result of a second meeting in the present temper of America, and under all the disadvantages I have mentioned. These are the people who will be calling the convention. If we're going to do this, we've got to understand the pitfalls. We got to understand the challenges there are to overcome, because there's challenges in nullification, there's challenges in Article 5. Article 5, who are the delegates? What is their motivation? When will it be done? Who will be in control? What will be the scope and impact? And who will enforce the amendments? You see, we already have a Constitution and a Bill of Rights, don't we? How well are they following that one? We create new amendments. Who's going to enforce these? Nullification. What are our challenges with nullification? Ignorance of the process. Fear of the unknown. States actually standing their ground. Right? They stand up to nullify, and then when the feds say, well, fine then, we'll pull your federal funding, and their knees quake, and they go, oh, never mind, we made a mistake, we're so sorry. What will be the scope and impact of nullification? And who can we actually embolden with the power, with the authority and the courage to stand for the state powers? Nullification plus Article 5 equals limited and defined government. Because the federal government has to be limited in order for these things to work. And the states must be sovereign. The lesson that I've taught you today is in this book. How many of you were able to take notes down and remember everything that I just told you? How many of you can think of at least 3 people who should have been sitting in this room with you right now? We'd have been hanging them from the ceiling, Mr. Dennis, but we got them in here, right?
Amen.
Okay. Well, now you can take this book with you. Tomorrow, I wrote this down. Tomorrow I will be teaching a course on state sovereignty at the Commerce Township Library at 7 p.m. in Commerce Charter Township. You guys know where that is, right? Okay, I have no idea what you know. I will be there teaching my lesson on state sovereignty at 7 p.m. What I'm teaching tomorrow is the lesson that I have taught the legislators of Utah, Kansas, Arizona, and Oregon. I think that if I can teach state sovereignty in Oregon, I should probably be able to do that in Russia. Okay? We are currently scheduling to teach in Massachusetts, Washington, and Idaho, and Michigan. If you want to help us push the state sovereignty training for your Michigan legislators, please take a card and email me, and we will put you on the email list. And we will let you know when it's time to contact your legislator and say you need to go. Now, this book teaches the lesson that I have taught you today, teaches lessons on state sovereignty, on the incorporation of the constitutional sheriff, teaches nullification, Article 5, and also teaches the lesson that I teach to the legislators. And so, we can do this, right?
We will do this.
We will do this, right? And guess what, though? To whom much is given, much is required. You now know the truth, which means you're responsible for spreading and prospering the truth. We could have 4,000 people in this room, Mr. Dennis.
Yes, ma'am.
And if everybody left the same way they came in and did absolutely nothing,
Wouldn't matter.
we just had an empty room. Our children are depending upon us. Now, I have lots of books over there. Elizabeth, okay, let me introduce you to Elizabeth, because we didn't do that before. Elizabeth is my intern. She is the very first Liberty First intern. It's something we've been wanting to do for a very long time. And Elizabeth and I met when I was teaching in Idaho. She is from Idaho. And I have been praying about having an intern forever. But I never really felt like it was something that I could afford to do, because you realize I teach without speaking fees. Nobody pays me to go anywhere. We have groups that support us, we have individuals that support us, and we rely on the sale of the books. I was like, but look, we were blessed to have extra money come in at the same time that Elizabeth and I met each other. I haven't called you Samantha yet, have I? Good job. Sorry, inside joke. Elizabeth is 17. She just graduated from high school, and she is an amazing young lady. Absolutely. You have to shake her hand and tell her thank you. We told Elizabeth that if she comes on board, it's going to be a very rigorous schedule. Eating and sleeping are done when we're able, because we do travel a lot and teach a lot. She's been helping me with my radio show every day. I have a radio show that airs 6 days a week. I'm very proud to say that it is syndicated in the United States, Canada, and in the UK. We estimate we serve at least 20 million people every single day. That's amazing, isn't it? I mean, look at it. We're just us, right? And so now 20 million people know Elizabeth. And now you do too. So please shake her hand and tell her thank you. Elizabeth is going to show you that I have books for children.
See if I can find them.
These books teach our young people the truth about the history of our Constitution and about framers and founders they don't get to hear about anywhere else. How many of you realize we're not teaching our kids the truth about the Constitution in schools? That means we as parents have a responsibility to change that. I'm going to give away a copy of this book to the person who can answer this question. Now, here's the caveat. When I ask this question, if you know the answer to this question because I taught you, you're not allowed to answer. Okay? All right?
That's true. Dennis can't answer.
Dennis can't answer. Well, Dennis has probably read this book, so I don't know where it's at. Who held the second Tea Party meeting after the Sons of Liberty threw tea in the harbor? And I'll give you a hint. It wasn't Ron Paul or Rick Santelli. Anybody know? Yes, ma'am. Absolutely right! Give that lady a book. Just 10 months after the men threw tea in the harbor, the women got together under the leadership of Penelope Barker in Edenton, North Carolina. They made a pledge that they would purchase no English-made goods until the laws that had enslaved their people were repealed. And then they made this statement. We're going to sign our names to this pledge. Not hide ourselves behind costumes like the men in Boston did at their tea party. The British will know who we are. Calling out the men for being cowards, hiding behind costumes and saying, we're going to do something bolder than that. These are the women that our daughters should be looking up to. I also have a homeschool DVD. This is brand new. This is just for students, high school, middle school level. We filmed this while I was teaching a middle school in New Mexico. This is a 1 DVD. It is about, where's my husband? Oh, he's in the other room? Okay. I think it's about 40 minutes long. He did all the editing, so I don't know how it ended up. But we have that. We also have a 3 DVD set of a workshop that I teach on Saturdays. Anybody here been to my 5-hour workshop? Yeah? Anybody? How would you like me to come back here and teach the workshop? Well, there's a catch. All you have to do is promise to spend 6 hours with me on a Saturday. Because I have no speaking fees for that one either.
And it's totally worth it.
We have the Sovereign Duty book, but we also have this book, Liberty First, The Path to Restoring America. This is what I call Constitutional Activism 101. How do you turn your First Amendment into a tool to educate, preserve, and prosper liberty? Let me give you a quick pop quiz. Nobody answer out loud. Just keep the answer in your head, okay? The First Amendment has 5 liberties. Name all 5.
I heard it had 6.
That is not so, and we can talk about that later. But there are 5. We have a Supreme Court justice in Florida who took a poll, found out that only 2% of the people polled could name all 5. Let me ask you this question. If you don't know what your rights are, how do you know they're not already gone? Freedom of religion, freedom of speech, freedom of press, the freedom to peaceably assemble, and the right to petition the government for a redress of your grievances. Some people like to break the freedom of religion down into government can't establish religion or prohibit the free exercise thereof. The problem is, it's a difference without distinction. You cannot break them apart. They are not independent. There's no way for the government to eliminate your freedom of expression without preferring religion. See, establishing a religion doesn't mean that they have to step up and stamp and say, we are now a religion of Muslim, right? We are now the Islamic religion in this country. No, they simply have to say, this religion is better than that one. Or this one is thought of less likely than other by government. There's a hierarchy. That's the same as establishing religion. And prohibiting your free exercise thereof is establishing a religion. I believe that our framers, and I think you can find this in their words themselves, they put in those 2 clauses not to make 2 different points, but to show us the most 2 common ways that our religious liberties are abridged and interfered with. So, that's what we have. And I want to thank Mr. Dennis for bringing me in. Everybody give him a round of applause. Thank you, Champion, for bringing me in. Don't forget about the township tomorrow. We'll be doing that. God bless you.
Well, God bless you. KrisAnne, before you go, besides everybody buying the books and giving contributions, I want to give you a gift. I was fortunate to be able to go to Ron Paul's 80th birthday celebration over the weekend, and we have, thanks to Shane, he actually procured these, but a copy of his latest book, Swords and the Plowshares. He was the champion of the Constitution. I can think of no more appropriate gift to give you, and thank you very much, ma'am. You are outstanding. And a big round of applause again for KrisAnne Hall.